Hi, welcome to the first installment of Frequently Asked Friday here at Martin IP Law Group, where we answer your questions about intellectual property and related matters. Today's topic, we're going to talk about patents, and we're going to talk about what are the requirements for a patent. Basically, there are three main requirements in order to get a patent. The first thing you need to do in order to get a patent is your invention must have utility, which basically means it must be useful. That typically means it's got to be a process, a product, a device, something along those lines that has utility and has usefulness. I don't think I've ever had a client come into my office wanting to patent something and I had to tell them it wasn't useful. It doesn't have to be useful to everyone, it just has to be useful to someone. So if you have an idea and it's useful to you, it's probably going to meet that first requirement. The usefulness requirement is the easiest hurdle to overcome when it comes to requirements for a patent. The second requirement is the novelty requirement. Your idea must be novel. And what does that mean? Novelty is essentially there can't be anything exactly like it that's been done before. So if somebody else has already come up with your invention and it's in the public domain, you can't patent that. And by public domain, there's a concept in patent law called prior art. So if your invention is known in the prior art, then you can't patent it. And what prior art is basically anything that's known in the public domain. So it could be another patent. It could be a published patent application. It could be a blog post. It could be a newspaper article. It could be a book. It could be any internet link or story on the internet. Anything that's out there and publicly available in written, video, or other forms is prior art. So if there's prior art that predates your filing of your application for patent that's exactly like what you have, then you don't meet the novelty requirement and you can't patent your invention. The third requirement is non-obviousness, and that's a little bit more of a subjective question. The technical test that the patent office applies is, would it have been obvious to a person of ordinary skill in the art at the time of your invention, knowing everything that's out there in the public domain, maybe to take features of this this piece of prior art and features of this piece of prior art, combine them together to come up with what you've invented. So the test is, would it have been obvious to a person of ordinary skill in the art who, that term varies depending on what your invention is. So if it's, a rocket scientist is going to be, the person of ordinary skill in the art. If it's a plumbing device, a plumber is probably going to be the person of ordinary skill in the art. So that person, varies depending on what your invention is. But would it have been obvious to a person of ordinary skill in the art, in whatever art it is, to take features of one thing that's known out there in the public domain, combine those with features of something else to come up with your invention? That test is by nature a backward-looking test and a very subjective test. So that's an area that's fertile for argument in the patent application process. We come across obviousness rejections from the patent office all the time, and through various arguments, we're oftentimes able to overcome those. So again, those are the three requirements for obtaining a patent. One, it's got to be useful. Two, it's got to be novel. Three, it's got to be non-obvious. So if you meet those three things, then you can patent your invention. If you have something that meets those standards, feel free to give us a call, schedule a consultation, come in and talk to us, and we'll see how we can help you obtain a patent on your invention. Thanks. We'll see you next week.